Hey guys, welcome to this video. We're going to talk about if you are sued by a debt collector, but you know that debt collector has violated the law, should you file a counterclaim? We'll look at your three options. So welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and we put out these types of videos every day. So if you've not subscribed to our channel, feel free to do so, and then you'll be notified when we put out a new video. All right, so very simple situation. Let's just use Midland Funding as an example. Midland Funding has sued you. And so you've got to deal with that lawsuit. But you know Midland Funding has violated the FDCPA. Maybe you've already disputed this debt and they're not reporting it as disputed on your credit report, but they are credit reporting on you. Or maybe within the 30 days after Midland sent you a notice under what's called 1692G, that says you have 30 days to dispute and all that sort of stuff. You request verification from them and they don't respond. They just sue you. Okay. Whatever it is, you know that you have at least a violation by the debt collector of the FDCPA, Fair Debt Collection Practices Act. So what do you do? And this was a question asked by, I believe, DIY Dad on a recent video. I thought it was a very good question. So one option is you can file a counterclaim. Okay, so Midland sues you, you sue them right back in a counterclaim. So whatever court they sue you in, that's what court you're in. Maybe that's small claims court, maybe it's called general sessions, maybe it's called district court, circuit court, wherever they sued you. That's where your counterclaim is. The same judge will hear both sides of this lawsuit, the collection lawsuit and then your counterclaim. Or maybe file a separate lawsuit. So you say, okay, you sued me in this court, but I'm going to sue you, Midland, in this other court. Or maybe if you feel like you will win, you say, well, I'm going to wait till I win my case, and then I'm going to sue Midland. So these are the three basic options. Let me give you just real quick kind of pros and cons of each one. One advantage of doing a counterclaim is sometimes that convinces the debt buyer to say, you know what? I've got a claim against you, you got a claim against me. Let's just go our separate ways. Okay, and that can be an advantage. Typically, it's either doesn't cost any money to do a counterclaim or very low filing fee cost. Okay, as opposed to filing your own case. All right. Now, a downside is you may be having a judge look at your FDCPA claim who knows nothing about the FDCPA. And you'd be much better off with a judge who has experience with that. And, you know, this has kind of been my approach over many years. And it's not always true, but it's pretty often true. If you have a legitimate FDCPA claim, then I think you should bring that in a separate court, not a counterclaim. A counterclaim, at least in a lot of places, sort of has the feel of, well, you're just doing this to kind of take a shot at them, but you don't really have a good claim. Now, that's not always true, certainly, but that's kind of the impression. But it's definitely an option. Now, what about a separate lawsuit? Well, the advantage of that is you can pick the court that you want to be in. Maybe you want to file in federal court, or maybe you want to be in your higher state court. You might be sued in small claims by Midland. Maybe there's a limit on how much can be claimed. So, you know, you might say, well, I really need a higher amount because I want to sue them for more money. So then you go to a different court. That's the advantage of it. And you can make sure that you're in a court that typically has a judge that will know what these types of cases are. Now, the downside is it's more expensive. And, you know, you're kind of fighting on two fronts here, right? You're in the lawsuit where they sued you and you're in the lawsuit where you sued them. Now, they may still say, if they think there's any merit to your case, well, hey, you drop your case, I'll drop mine. Okay. And you may be out more money with the filing fee by doing that. But this is certainly an option, and particularly if you don't want to do a counterclaim, but you cannot wait as long as it will take for option 3, which is to win your case. So let's talk about that. With the FDCPA, there's a 1-year statute of limitation. A lot of times, if we catch these guys violating the law, it will be because of the actual filing of the lawsuit. Now, it can be other things. But if it's the filing of the lawsuit, That's the trigger date. Now, you might not have been served for a couple of months, but most courts say it's the date the lawsuit was filed if what you're suing for arises out of that lawsuit. So if you are in Alabama, where I practice, and you're sued in our lower courts where we don't have juries, typically, not always, I mean, there are times where it's much different, but most counties, you answer the lawsuit, you're going to trial in 3, 4, 5, 6 weeks. Okay. Now, my friends in California who do this, they say, John, we get to trial in 12 to 18 months after we file an answer. Well, that's too long to wait. Now, maybe in Alabama you can wait. So there are times where we know we have lawsuits against the debt collector, and we're kind of keeping an eye on the clock, saying, okay, well, they sued me, let's say in March of 2020, the end of March, and if I don't think I'm going to get my case tried by March of 21, then I may have to file that as a separate lawsuit or even do it as a counterclaim. So you do have to have some strategy here. The judge that typically who your judge is on the collection lawsuit. Is that a good judge? Is that a judge that understands the FDCPA? Is that a judge that thinks every consumer that allegedly owes money is just terrible? Well, maybe you don't want your claim brought in front of that judge. Okay. Maybe you have a great judge. How about statute of limitation? Do you have time to wait for option number 3 till you win your case? So there's all different options there. What I would do if you're in this situation, even if your original plan is to handle your FDCPA case on your own, or let me restate that. If your original plan was to handle the debt buyer lawsuit on your own, so Midland sues you, say, I'm going to handle that on my own. If you have a legitimate FDCPA case, I think you're always going to do better to go get a lawyer who really knows what he or she is doing with the FDCPA. I mean, we have people that will come to us after they have filed their own FDCPA case, and they go, look at this, I did fantastic. I got $2,000 out of this. And, that was a good deal, right? And I look at it and I say, some cases that might be a good deal. And if they really, really push me, they're like, no, I want the truth here. I'll say, I would not have settled your case for less than $50,000. They're like, really? I thought I was saving money not hiring a lawyer. I'm like, no, you never save money not hiring a lawyer if you're bringing an FDCPA case, because there's what's called fee shifting, where the other side can be forced to pay your attorney's fees. So it's worth talking to a lawyer in your state that does the FDCPA, because they may say, well, I can defend you also. And, that may be, they may charge you a fee for that, but maybe that's going to be paid out of the FDCPA lawsuit. So all different types of combinations here. But my advice is talk to a lawyer. If you don't know a consumer lawyer in your state, reach out to me at alabamaconsumer.com. Just fill out the contact thing. Say, hey, here's what I'm dealing with in this state. Do you know somebody? Some states I do, some I don't. If I don't, I'll just give you sort of a general link that will take you to a consumer law website, and you can see if there's a lawyer there that you can connect with. But sometimes I go, hey, anybody in this state, I always recommend they go see so-and-so. So always feel free to do that. And now don't call me, because I'll just be honest, I get so many calls a day from people. And, if I'm sitting in court, I can't talk on the phone. But if I'm waiting on my case, I can respond to emails. So just fill it out through my website, alabamaconsumer.com. And really, you and your lawyer have to put some thought into this. It's a very important decision. Do you do the counterclaim? Do you file a separate lawsuit? Or do you say, we're going to wait till we win, and then there may be other claims? Because remember, if you win, that may be a claim in and of itself if they didn't even try and prove their case at trial. And what happens to credit reporting? We have other videos on this. When you win, that credit reporting should go away. So sometimes we know, hey, this is a debt buyer that's crooked. If they're violating the law now, then I beat them. They're going to keep it on my credit report. And then maybe I can dispute it through the credit bureaus, and they're going to keep that. And that might change the value of your case from a $2,000, $3,000, $4,000, $5,000 case to, if you win your case and dispute it, dispute it properly, it doesn't come off, that debt buyer may be paying you $30, $40, $50,000. Each credit bureau may be paying you $25,000. You see what I'm saying? Sometimes it can be worth a whole lot more if you can wait, but you have to set it up properly. You have to make sure you're following all the rules and that you have a lawyer that's helping you that understands about this area of the law. So hope that this is helpful, guys, and I will chat with you tomorrow. Have a good one. Bye-bye.